you. My name is Nicola Allsop. I'm a barrister at Quadrant Chambers and I've been practising in insolvency law for over 15 years. The title of this QBiT talk is How to Stop a Winding Up Petition. So a client contacts you, a creditor is threatening to wind up the client. What do? I am going to tell you in 4 easy steps. I'm not suggesting these steps are taken sequentially. Invariably, there is a real need to act with urgency where winding up proceedings are concerned. The presentation of a petition can lead to the immediate freezing of the company's bank account with disastrous consequences. So you might have to take all 4 steps on day 1. You might not be able to take all the steps as fully as you would like before having to apply to court. But first, you need to find a genuine dispute or a counterclaim. Focus on the debt claimed by the creditor. Is it based on a judgment or contract, for example? If it's based on a judgment, the insolvency court will not go behind the judgment on a winding up petition. So consider whether an application can be made to set aside that judgment or whether it can be appealed. Is the debt admitted in whole or in part, or is it disputed? If it's admitted in part, can that part be paid, and how quickly can it be paid? The court will restrain a winding up petition if satisfied that there is a genuine dispute on substantial grounds. So if it's disputed, what are those grounds? Alternatively, perhaps your client has a counterclaim, and the court will also restrain a petition where the company has a genuine and substantial cross-claim. So you need to take instructions. How does the counterclaim arise? Has a demand already been made in respect of it? That's quite useful in rebutting an argument that it has just been set up to defeat the threat of a winding up petition. What is the value of the counterclaim and how is that value calculated? The value is important because it needs to be the same or exceed the petition debt in order to defeat a winding up petition. Step 2, what order are you going to ask the court to make if you need to go to court? The answer to that will depend on the stage the dispute has reached. Has a stat demand been served or a pre-action letter been sent? Worst case scenario, has a winding up petition already been presented? And if so, how advanced is that petition? Has it already been served on your client? The stage is important because if a petition hasn't been presented, the relevant application is to restrain presentation of the winding up petition. Even where it's based on a stat demand, it's not an application to set aside the stat demand, and it differs from bankruptcy in that regard. If your winding up petition's already been presented, the relevant application is one to restrain advertisement of the petition. And if you're successful on that application, not only will the creditor be prevented from advertising, he will also be restrained from prosecuting the petition, so that'll bring an end to the petition. Third step, if time allows, make contact with the creditor. Now, there will be cases where the urgency is so great, it's simply not practical to contact the creditor and wait for the creditor's response before going to court. But where there is time, put the creditor on notice that the debt is disputed or that the company has a counterclaim. Summarise the dispute or counterclaim, saying if appropriate that further instructions are being sought. Make the point at the outset that to present a winding up petition in those circumstances will be an abusive process. And point out the cost risk. Presenting a winding up petition in the absence of a judgment is a high risk strategy. So if the petition is unsuccessful, the company is normally entitled to its costs on the indemnity basis. The key point here under step 3 is to exercise some control over timing. For example, you might need more time to obtain instructions, and if you do, you can request an extension from the creditor or an undertaking that he will not present a winding up petition without first giving your client 72 hours written notice. It's harder to stop advertisement by consent as the creditor is subject to relatively strict rules as to when advertisement must take place, but you might be able to agree a short extension. If any indulgence whatsoever is refused and you have to go to court immediately, then you can point out the creditor's unreasonable behaviour and you might be entitled to apply for the costs of that wasted hearing. But what you're working towards under this step is getting to the point where you are in a position to ask the creditor for a permanent undertaking, that the petition is not presented at all, or if it's already been presented, that it's not advertised and it's dismissed at the earliest opportunity. But let's say, despite your best efforts, you have a foolhardy creditor who's hell-bent on pushing ahead, An application will need to be made at that stage for an injunction, either restraining presentation or advertisement. So, step 4. Under step 4, you will need 4 documents. The first is an application notice, and that's an insolvency application form. The second, evidence in support, by way of witness statement with an exhibit. Third, a draft order. And fourth, a skeleton argument, although of course in a very urgent case, it might not be possible to prepare a skeleton in time. In terms of the procedure, the application must be made to the court which has jurisdiction to wind up the company. In London, an application can be heard by an ICC judge, that's an Insolvency and Companies Court judge, or by a High Court judge. Outside of London, the application can only be heard by a district judge if that district judge has permission from the supervising judge of the relevant circuit. So some care needs to be given to make sure you're in front of the appropriate judge. The application is likely to be urgent, but in most circumstances it will not be necessary or appropriate to be heard ex parte. So consider going on very short notice. My advice would be to send an email or make a telephone call, just explaining to the creditor which court you're going to and when. And in terms of the approach to be adopted at the hearing, it's quite useful to think of this application as you would a summary judgment application. Your job on behalf of the company is to convince the court that there is a genuine dispute on substantial grounds, which is not suitable to be determined in the context of a winding up petition. So a dispute of fact, for example, which can only be resolved following the cross-examination of relevant witnesses at trial. The winding up procedure does not allow for cross-examination and so on, and so will not be appropriate in those circumstances to continue with such a petition. Alternatively, a genuine counterclaim. You might need to explain why no claim has been issued in respect of your genuine counterclaim. Make sure you have an explanation ready. Those are the 4 simple steps you need to take when a client is threatened with a winding up petition. Thank you for watching.